let's talk about Quebec's proposed legislation that would force streaming platforms like Netflix, Spotify, and YouTube to make francophone content more visible and accessible or face steep fines. Let's find out if it's even constitutional for Quebec to do such a thing. Michael Geist is with us. He is Canada Research Chair in Internet and E-commerce Law at the University of Ottawa. Michael, welcome back to the show.
Oh, thanks so much for having me.
So what do you think? Whenever a government tries to get involved in what media companies and streaming companies do, you always have an opinion. What do you think about Quebec's foray into that?
Oh, I think there are real concerns. Both some of the constitutional issues that you mentioned, we can get into those. But also I've got real concerns about what the real outcome will be. It seems to me that in many respects, the most likely outcome for Quebecers is either that some of the services block access to them altogether, they essentially shut out the market, or they start removing non-French language content from the service. Because it's not just about finding French language content, it's about quotas that are included in the law as well.
Okay, now that's interesting, because in my mind, this was about the homepage, and while I'm not a fan of it, by the way, I don't like this at all, I'm like, okay, well, if it's just what shows up on the homepage, that's different from the content in general. You think that, Netflix and the Craves of the world would have to remove some content?
Oh, I don't think there's any doubt that they'll have to remove content. There are quotas, and the government hasn't yet identified what that percentage is going to be. But let's understand how a quota functions when you're dealing with a large library like a Netflix. Let's say they've got 100 films. They've got obviously far more than that. But if they have 100, if the quota says 30% of them have to be French language, they've got to start working backwards. First, they've got to find that content. And it doesn't have to be Quebec-based content at all. There's actually no reference to any of this being Quebec-based content. It just has to be French language content. But then you've got to ensure that you hit that 30%. And so what you begin to do is to remove some of the other content so that you hit your 30% requirement. And that essentially means that you start removing some of the non-French content so that you can hit the percentage that you're required to hit under the law.
We've seen in other laws, like federal laws, we saw what Facebook, Meta, ended up doing when it came to news content, for instance. Do you think it'll be another example of that, where big tech giants say thanks but no thanks?
I think there is a risk there for sure, and part of it is that they're already dealing with the federal law, Bill C-11, or the Online Streaming Act, which they're in court fighting it in part because of some significant new costs they're going to face. The prospect of layering in all these additional costs at the provincial level may leave some saying, listen, this is the province effectively pricing itself out of what makes economic sense. And so it's just easier to block that market altogether and serve the rest of Canada with a singular service.
Let's talk about the constitutional issues. Why could this be a constitutional issue?
Well, because we've got long-standing case law and questions about who's got responsibility over communications law. And in fact, the courts have decided it's the federal government. And so there have been actually questions as to whether or not the federal law is constitutional. It comes down to whether or not you think internet streaming constitutes broadcast. Now, if it constitutes broadcast, the federal law applies, but then it's hard to make the case that a provincial law would apply as well, because then they don't have the same kind of power over communications issues. If internet streaming isn't broadcast, and some people have tried to make that argument, then actually the Quebec law could effectively be constitutional, but the federal law would not. I think at the end of the day, it's hard to make the case that the two laws can coexist. I mean, at the end of the day, they are trying to regulate the same thing, and responsibility for this kind of regulation has to rest with one or the other, and typically we would say it rests with the federal government.
Michael, I think if there's anyone that knows what content to show me, it's these streaming services. They've made a name and they've made lots of money knowing exactly what to show people, or else they wouldn't be successful in the marketplace. But is there any room for any type of government hand in questions like this, like the surfacing of content?
Well, listen, even as part of C-11, there have been discussions about, as you suggested, on the homepage, having some kind of promotion of local content. I think the services already have all the incentives they need to do that. If that's what the local market is looking for, they're not going to try to hide that content. They're going to be anxious to try to ensure that locals have access and can find it. But if you were just talking about something like that, that doesn't feel all that intrusive. But once you start getting further into some of the quotas that we talked about, it raises concerns. And fundamentally, this notion that somehow it's hard to find, say, French language content feels as if this law has been drafted by people who've never even used Netflix. I mean, quite literally, on the front page, there is a bar there that says, "Show me French language content," and all you got to do is click.
Now, let me ask you this, because many people have said, you know what, we've done this before in Canada. We have CanCon rules for radio, whether it's French language for French language radio stations. So we've done this before. Why is this different from that?
Well, I think it is different. In the days of radio and television, we had a limited number of players. They're subject to license. And so because there was, in a sense, scarcity of the delivery channels, we've made the argument that it's appropriate to come with the privilege of having some of those limited powers, those limited rights to be able to be the broadcaster. You've got to meet certain standards. The internet is just totally different. I mean, anybody, of course, can upload a podcast. Anybody can access what they want, and it is an unlimited library, in effect, on many of these services. And so this notion that you would impose quotas on a place that there is an unlimited amount, in effect, of availability, the two can't coexist. You can't have a percentage and at the same time say the amount of content theoretically available has no real limit. That's far different than, say, radio or television, where there can only be one program on a particular channel at 8 p.m. in the evening.
Michael, got to leave it there. Always appreciate your perspective. Thanks so much.
Oh, my pleasure. Thanks for having me.
That's Michael Geist from the University of Ottawa.